In this video, we're going to be talking about plenary guardianship versus guardian advocate. In this workshop, we teach how to get guardianship using Florida's expedited guardian advocate program. But for parents like us, there are actually two options to get guardianship: plenary guardianship and guardian advocate. But in 99.9% of cases involving adult children with intellectual or developmental disabilities, the applicants get guardianship through the guardian advocate program. This being said, I want you to understand why we use the Guardian Advocate program as opposed to the plenary guardianship program in the unlikely event this issue comes up like it did for me in my case with Leah and Moreland, which I discussed in the previous video. The Guardian Advocate statute was specifically written to help parents of children with disabilities get guardianship in an expedited fashion. It's important to note that under either the plenary guardianship program or the Guardian Advocate program, functionally, there's no real difference to the rights that the guardians have, meaning that the court will remove certain rights from the ward and permanently assign those rights to the guardian. And once those rights are assigned, the ward has no legal right to make those decisions for him or herself unless the rights are restored by a court. Parents of children with intellectual or developmental disabilities can get plenary guardianship, and I've actually had a client who did this, but it is highly unusual and happens most often when the parent just didn't know that the guardian advocate process existed. Typically, plenary guardianship is used in cases where a person is elderly and can no longer care for him or herself because of something like a stroke or dementia or severe mental illness. In a plenary guardianship proceeding, the applicant must be represented by an attorney, whereas in the Guardian Advocate program, there's no requirement for the applicant to be represented by an attorney. And of course, Guardian Advocate's flexibility with respect to counsel is what makes it possible for you to take this workshop and save a bundle of money for your family by filing your application pro se, that is, without a lawyer. With plenary guardianship, as part of the court proceeding, a panel of professionals is appointed to determine whether or not the ward has capacity, and guardianship can only be granted if the panel determines that the ward is in fact incapacitated. By contrast, through the Guardian Advocate process, no determination of capacity is made, but instead, the ward must have an enumerated or other developmental or intellectual disability, and the judge relies on a diagnosis submitted by a physician and one other piece of official documentation, which in most cases is a copy of your child's IEP, to verify the ward's disability. Now, the word plenary, in a legal sense, means full or complete. So with plenary guardianship, all of the decision-making rights are removed from the ward and appointed to the guardian, meaning that the guardian is awarded full guardianship. However, under the Guardian Advocate program, the ward does not have to be fully incapacitated and can retain some of his or her decision-making rights. And in fact, as I mentioned in the story about Leah in the previous video, the guardianship statute encourages the courts to adopt the least restrictive guardianship option, the one that will allow the ward to retain as many rights as possible. Now, with plenary guardianship, as I just mentioned, the ward must not have capacity. And as I also discussed in the story about Leah and Moreland, you know that to qualify for the Guardian Advocate program, the ward must be able to make some, but not all, of the decisions to care for his or her person or property with a liberal interpretation. In terms of the time it takes to get guardianship, under the plenary guardianship program, because the capacity must be determined by a panel of professionals, it takes a lot more time to complete the guardianship process as compared to the Guardian Advocate program, where you're submitting a physician's report and an IEP in lieu of a panel determination. Finally, when comparing the two forms of guardianship, there's the expense. Plenary guardianship is very expensive. Number one, you have to hire an attorney, and any legal process that takes more time always costs more money. Then there's the expense of the panel review, which must be paid out of the ward's assets. But if the ward is under the age of 18, then it's the responsibility of the applicant to pay for all of those fees. By contrast, under the Guardian Advocate program, there is no requirement to hire an attorney. So if you're able to complete the application process on your own, obviously you can save a lot of money. So to sum things up, when you have a guardianship program that's specifically designed for adults with disabilities, that's faster and costs much less money, you can understand why the vast majority of Florida parents getting guardianship for children with disabilities use the expedited Guardian Advocate program. See you in the next video.